It's a focus on how cities in the U.S. address homelessness, an issue on trial at the U.S. Supreme Court today, with Oregon taking center stage. The city of Grants Pass was sued by people who are homeless in the Oregon city. The Supreme Court hearing whether the city's restrictions are considered cruel and unusual punishment. Thanks for joining us at Queens News at 5. I'm Elizabeth Dinh.
And I'm Ken Boddy in for Jeff Gianola. We have the breakdown from Washington, D.C. coming up. But first, we're finding out how this could affect cities in Oregon. Our Brandon Thompson digging deeper into that. He's live at the U.S. District Court in Oregon tonight. Brandon?
Well, there are groups who support Grants Pass's position on this who tell me that cities need the clarity in order to create rules to address homelessness. Groups who support the status quo and the case law at this point say that cities already have the tools to address homelessness by building more shelters and housing. There are three things Oregon cities must consider in creating rules and laws around camping. First, the district court case Martin v. Boise says there must be adequate shelter in order to ban camping. That ruling became one basis for Grants Pass v. Johnson, which finds cities cannot create rules that punish people just for being homeless.
There's very little guidance in the cases about what is legally permissible at this stage, and it's not clear what it means for someone to have reasonable access to shelter.
Cities and municipalities keep screaming that this decision has tied their hands. That's really not the case.
Chavez says cities have the tools to create enough housing and shelter, and that should be their strategy to address homelessness.
Cities already have the ability to move camps, to move tents. They can do so with notice. They can do so with their police or with other entities from their municipalities. What cities apparently want is to be able to also jail and fine people for being houseless.
The League of Oregon Cities they've been looking for on this has been flexibility and workability to ensure that public spaces are safe for all communities.
The third thing cities must consider in Oregon is a state law, House Bill 3115, that states cities must have reasonable restrictions on where and when camping can take place. Portland's attempt to create those restrictions have been temporarily blocked by a court, and more attempts to create the rules are expected later this week.
It's quite costly for a small city or even a big one to spend years in litigation trying to understand the contours of whether an ordinance is enforceable. That really does tie the hands of cities.
So legal experts I'm speaking to who listened into the Supreme Court hearing today do expect the Supreme Court to change the current case law. They're just not sure how far the Supreme Court will go, if the justices will make a more narrowed ruling or a broader ruling that applies more specifically and agrees with the Grants Pass case. Live in downtown Portland, Brandon Thompson, KOIN 6 News.